Welcome to the podcast. I'm your host, AJ Richmond, criminal defense attorney here in Georgia. Tonight's podcast is going to be about bond and the bail process in Georgia. Now, most of the calls that I get occur when the person is in jail and the family or the friends, somebody's trying to get him out. This is the process that we call bonding. There are multiple ways to sort of get someone out of jail, and it really depends on the county that you're doing it in. So I'm going to be specifically talking about a county where I'm at, in Forsyth County, but other counties pretty much do it the exact same way. But what's happening is the judge or the officer has arrested the person, and there is a bond that needs to be set. And what a bond is sort of a financial assurance or a financial agreement between you and the sheriff that this person will come to court when he gets out. And you may say he'll come to court, and the person may say they'll come to court, the person that's in jail. But the sheriff doesn't know them personally, and in all counties, we have to get them out, usually with money. So, a lot of times, there's something called a schedule bond. And what that is, if you think of it like a DUI case, the person gets arrested, and within 6 hours, 10 hours, you can go with, a couple $100, maybe $1,000 or so, and bought them out of jail. And that's because those misdemeanor charges, most if not all misdemeanor charges, are all set with a bond amount that's previously known. For example, a DUI might be a $5,000 bond, or a public intoxication might be a $1,000 bond. Possession of marijuana might be a $1,000 bond. And it's really to get people in and out of jail as quickly as possible. But what happens is when you start getting arrested on the bigger offenses, the bonds tend to get higher for really no other reason but for the fact that people think that charge is obviously more serious, like aggravated assault, like false imprisonment, like aggravated stalking, possession of Scheduled 1, Scheduled 2 drugs. And there needs to be a financial assurance in those cases that you'll come back to court, simply because the punishment in those cases is much higher. They're much higher than misdemeanor punishments. Typically, those punishments could involve prison. It could be involving, or you could be a convicted felon. And there are lots of cases, especially ones that I handle, where the punishment could be 25 years to serve in prison, life, 30 years to serve in prison. And those bonds clearly, according to the sheriff and prosecutors, need to be higher. So what happens is when you go to jail, there's a bond set, and let's say the bond is $10,000. There's different ways to get people out of jail. So the first way, and the most common way, is to use a bondsman. And in the state of Georgia, bondsmen's charge anywhere from 12 to 15% of the actual bond. So in a $10,000 bond, $1,200 to $1,500. And what's happening is, instead of you going to the jail with $15,000 or with $10,000 to bond out your family member or your friend, and giving $10,000 to the sheriff, you're giving the bondsman $1,000 or $1,500 in exchange for the bondsman posting or putting up the $10,000 risk. And the reason for that is, first off, bondsmen know how to get people in and out of jail faster. They can keep track of people faster, but they're taking the risk. They're taking the risk that if your friend or your family member doesn't return to court, they're out, the bondsman's out, 10 grand. And you're not taking that risk. Of course, you may not have $10,000 in cash to give to the sheriff to get your friend out of jail. You may only have $1,500 or $2,000. So the bondsman makes your life much, much easier. And frankly, when you're in such stress that you're in at that time, the bondsmen know how to do things. They know the people to talk to. They can tell you when your friend's going to get out of jail or your family member's going to get out of jail. So you don't have to sit there all night and wait. They sit there for you. They're the ones that you're paying to do all that. So that is what's called using a bondsman to get out of jail. And again, that's the most common. And there's lots of bondsmen out there. But those bondsmen that are assigned to each jail are trusted by the sheriff. They're personally vetted by the sheriff to be reliable bondsmen. So you should know and be assured that when you pay a bondsman $1,500 or $2,000 on a $10,000 bond, they're going to show up. And of course, we want to also think that a lot of these big bonds, they're not $10,000. Bonds that I deal with sometimes are $50,000, $75,000, $100,000, $350,000, and I think the highest bond I've ever had was about $375,000 bond. So you would pay a bondsman, $30,000 to $50,000 instead of giving the sheriff $375,000. Now, on that note is what's called a cash bond. And that is sort of the same as the bondsman, except now you become the bondsman. So going to my example of posting the $10,000 bond, instead of using a bondsman and paying the bondsman $1,000 or $1,500 or $2,000 if it's $10,000 bond, you would pay the $10,000. So you would say, well, AJ, why would I use a bondsman if I just have $10,000? Well, the answer is, a lot of these cases take 2 years, sometimes more, to go through the court system. Can you live without that $10,000 for 2 years? And that $10,000 is being held by the sheriff's office. It does not grow interest, so it sits at $10,000. The day that at the end of the case, it's still at $10,000. There's no interest on it. And if you have that money and you can give that to the sheriff, by all means do it. And you'll have to figure that out with the sheriff, how they accept the cash bonds and what other proof you need to give. Now, when do you get that money back? When do you get the $10,000 back? You get it back at the end of the case. So if I'm representing somebody and you post the $10,000 bond for that person, you'll get that money back when two things happen. One, your friend has to attend every court date, and he can't miss. If he misses, that's called a bench warrant. And two, the case has to close. Case is closed by pleas, by dismissals, and by trial verdicts. So when one of those three things happen, 2 years, then you'll get your money back from the sheriff's office or the clerk of court. The next type of bond, and another common bond, is what's called a property bond. Now, each county in Georgia has their own specifics, their own requirements, their own rules for property bonds. Some counties, you can't use property that belongs to the person in jail. You can't use property that is out of the county. You can't use property that has liens on it, like tax liens. You can't use property that has mortgages. Good rule of thumb is that the property that you're using has to be at least double the amount of the bond. Worth double. So let's say the bond is $50,000. You have to have a piece of property that has $100,000 in equity in it, twice the amount of the bond, that you can post. You can still have a lien on it, but you got to have about $100,000 in equity on a $50,000 bond. I will post a link to each county's website on my blog, so that way you can contact them and figure out what the rules are for the property bond. In my experience, property bonds are the slowest way to get someone out of jail because of all the hoops you have to go through. A lot of times you can only do property bonds from like 8 a.m. to 9 p.m. or 8 a.m. to 5 p.m. Pretty much during regular business hours. You gotta have the deed, you gotta have a lot of the paperwork, and it may require you to run around a little bit. But it might be worth it because you don't pay a penny when using a property bond. You simply are posting the property, which you'll get back as long as the person who you're getting out of jail attends court every time and closes their case, either with a dismissal, a plea, or a trial verdict. So you'll get the lien back on your property. Something to keep in mind: if you plan on selling your house in the next 2 years or however long that county's court case is open for, you can't use a property bond. You can't sell the house or transfer title in the property that you're posting on bond. There's going to be a lien on it, and it cannot be used. I hope you found this blog to be interesting and helpful in the bonding process, and you're likely listening to it when you're about to bond out somebody. You can always give me a call and I can help you out. But just keep in mind, in summary, the fastest way to get someone out on bond is to call a bondsman, pay them, have them do it. They'll package it up, they'll package the client up when he gets out, everything will be fine. The slowest way, but least expensive way to do it is using a property bond. And that might be the easiest way for you. You may have all these documents readily available, and they might be perfect. But it is the slowest way, in my experience, to get someone out of jail. So, property bond, the slowest and cheapest way. Bail bondsman, the fastest, most expensive way. Again, I'm AJ Richmond, criminal defense attorney. Thank you.